how can Disney take these stories that are hundreds of years old and turn them into copyrights and trademarks that they can enforce against other creators? Copyright law protects original works of authorship as soon as they're fixed in some kind of medium. You probably know that these historical fairy tales, they're in the public domain, which means even if they were copyrightable when they were written, they've been around so long that they're in the public domain. Anyone can use them. There's no copyright protection in the original story. But that doesn't mean Disney doesn't have copyright protection. When a creator takes something in the public domain and builds on it, makes their own expression of that public domain work, their additions can be protected by copyright law. So the story of Cinderella is in the public domain. It's not copyrightable. But Disney's expression of that story, that's where copyright protection exists. So their animation, the addition of the mice, all their little changes that build on the public domain work, that's copyrightable, and that's what they're able to stop other people from copying. So other filmmakers can make stories based on these folktales, but they can't copy Disney's additions to those stories. Remember what trademarks are protecting, not the underlying creativity, but the brand, the trademark that something is being sold under. Trademarks protect that designation of source. Trademark law allows those companies to stop other people from using similar marks to sell similar things. Nike can stop other shoe manufacturers from using their symbol, but they can't stop people from talking about the Greek god of victory. Delta could stop another airline from offering a service with a similar name, but they can't stop a company like Delta Faucets from existing and selling faucets. None of these other uses create a likelihood of confusion about who is selling a good or a service. Okay, but how does this all play out? Disney somehow still stops everyone from getting anywhere near their princesses. Unfortunately, in my opinion, the answer is money. Even if a new creator just wants to build on the folktales and doesn't have any interest in copying anything Disney's done, Disney's going to aggressively enforce their IP here. If an artist starts selling princess tiaras on Etsy, Disney's going to claim trademark protection in as much as they can. Even if there's a good argument that there is no likelihood of confusion, it's really unlikely that the creator is going to have the resources to make that kind of nuanced argument. The same goes for the copyright side of things. From a purely legal perspective, it's not copyright infringement to create your own version of Cinderella or The Little Mermaid, as long as you're not building on what Disney created. If you're building on the folktale, you're building on the public domain. The problem is if you get too close to what Disney created, you could get their attention and they could come after you just like with trademark law. And that's why I think the real problem is the disproportionate resources. Only bigger studios have the ability to walk this line, and even though there's nuance in trademark and copyright law that should allow creators to build on what's in the public domain, if you get anywhere close to the trademark or copyright protection that Disney's claiming, it's almost impossible for an independent creator to have the resources to fight back. This is a really nuanced area of law that I could go into way more detail about in both trademark and copyright. This video is just a brief overview. If you want to hear more about anything specific, let me know in the comments.